Hello, and welcome to Short Circuit, your podcast on the Federal Courts of Appeals. I'm your host, Anthony Sanders, Director of the Center for Judicial Engagement at the Institute for Justice. We're recording this on Tuesday, December 2nd, 2025, and we have a special guest joining us today, rejoining us for the first time in a while to talk about some special sides of the federal judiciary that we don't discuss very often. So I'm very excited to have her back on. We also have one of my colleagues, Katrin Marquez, here, and she's going to discuss a case from the 11th Circuit to do with the Federal Tort Claims Act. So we'll get to our special guest and her case from the 4th Circuit in just a moment. But first, Katrin. So Katrin works in our Miami office, and so it's appropriate she is doing a case from the 11th Circuit. Now, this is a case that, until a couple years ago, I think most of us at IJ never even thought much about. It's about a statute we never even thought much about. But now the Federal Tort Claims Act seems to be everywhere, partly because it's about the only way to get justice if you're dealing with the federal government. And we had a case, Katrin, at the Supreme Court last year on this very law. Isn't that right?
That's exactly right. And just like this case, it was also out of the 11th Circuit. And the specific provision of the FTCA that I'm going to discuss actually came up in our SCOTUS case. So there's a lot of interesting stuff going on right now.
Yeah, all kinds of parts moving around. So we'll get to that a little later. But first, our special guest is Aliza Shatzman. She is the founder and director of the Legal Accountability Project. So she came on Short Circuit and talked about this just when it started. That was a couple years ago now. It's been going for a while. She'll also discuss this case from the 4th Circuit that has to do with judicial accountability in a way, and what laws apply to the Article 3 of the federal government, stuff that you probably haven't thought much about, even if you're an attorney. But first, tell us a bit about your organization. A lot of listeners may be clerks, they may be law students, they may be hoping to clerk for a judge. That's often a wonderful job. I had a wonderful judge that I worked for. But you know what? Not every clerkship is wonderful. Maybe we don't like to say that out loud, but it's true. And so you're there maybe for when that happens. So tell us a little bit about your organization.
Yeah, so the Legal Accountability Project basically, holds the judiciary's feet to the fire on issues of sexual harassment. We are leading the charge against misconduct in the courts, and we're somewhat of a watchdog organization. So basically trying to ensure that more judicial clerkships are positive experiences and then extend support and resources to those who have a negative experience. I was harassed, unjustly fired, and retaliated against about 5-6 years ago. And then I discovered, when I tried to hold the judge who mistreated me accountable, that law clerks and 30,000 people who work for the federal judiciary cannot sue because we are exempt from Title VII of the Civil Rights Act and all federal anti-discrimination laws. Judges have legal immunity for harassing people, which might be of interest to IJ folks and podcast listeners. So the hallmark of our work is basically our nationwide clerkships database, Glassdoor for judges. It is a review platform. So if you are a law clerk or a former clerk, you can review the judge you clerked for as a manager anonymously if you choose. And students and recent grads who are applying for clerkships pay a small fee, $50 for students, $60 for grads per year, to access exponentially more information than you otherwise could about great judges to work for and some of the really abusive ones who everybody should avoid. We have about 2,000 surveys, over 1,200 judges reviewed. So that's a lot of what we do. It's a transparency and accountability initiative. And we also do some kind of legislative advocacy around the Judiciary Accountability Act, which would extend Title VII to the federal judiciary, and a couple other important pieces of legislation. And I spent a lot of time yelling at members of Congress and telling them you don't need to be in the majority to send an oversight letter. Obviously, I'm telling on my political party, but shouting at members of Congress from both political parties. So that's what we do.
Well, great. Well, she is very active and has been fun to watch her rise the last couple of years. So check if you want to check the organization out. We'll put a link in the show notes as always. And she's bringing us this case from the 4th Circuit. Now, it came out back in August, but it is currently an en banc petition is pending, and it's about an interesting wrinkle. Well, it's about a lot of things, I should say, but it involves an interesting wrinkle of federal employment, and that is, I actually didn't know this until not long ago, that federal public defenders, right, which we need in the system in order to protect defendants' Sixth Amendment rights to a representation, that they are actually part of the Article 3 branch. They're not part of, Article 2 or whatever. So they are supervised by the judges of that circuit. So that's like their ultimate bosses, which is something I didn't know. Maybe they have to have a boss somewhere. So I guess that's where they put it. But that leads to some complications when it comes to employment issues. And so tell us about this case from the Fourth Circuit.
Yeah, so Karen Strickland is a former federal public defender from the Western District of North Carolina. She worked in the public defender's office there from 2017 to 2019. She was harassed and constructively discharged and retaliated against. And after asserting her rights internally, she ended up suing the federal judiciary. But she raised constitutional claims because, as I mentioned a couple minutes ago, the federal judiciary is exempt from Title VII. Now, the federal judiciary is 30,000 people. It is law clerks, so some of us, we all clerked, I think. We know what law clerks are. Permanent court staff, so permanent court clerks, pretrial, probation, all the clerks in the office who are permanent folks. And public defenders. So pursuant to the Criminal Justice Act of 1964, public defenders became part of the federal judiciary. So they are also exempt from Title VII. So Title VII was passed in 1964, only applied to private businesses. In the 90s, Congress went and extended that to more federal workers, to folks who work in Congress, to the executive branch. The federal judiciary is just vociferously opposed extending Title VII to itself. Judges have legal immunity for harassing people. They are exempt from the anti-discrimination laws they interpret. The judiciary claims that they have their own internal process, and what we'll talk about in Strickland's case is that process not so great. That is called the Employee Dispute Resolution, or EDR plan. That's like the internal complaint process. You're being mistreated by your supervisor. You might file an internal complaint to try to get away from the person who's harassing you, try to get reassigned. Unfortunately, there's a lot of issues with EDR. One is that there are no monetary remedies. So you would assert your Title VII, you would raise a Title VII claim if you are harassed and fired and you're seeking monetary remedies. EDR does not really provide those remedies, which makes it kind of substandard. The other issue is that it's not an impartial process because the decision maker is the boss in your office. For law clerks, the presiding judicial officer is a judge in that office. It gets even weirder for public defenders, though, because we just talked about how there are no good remedies in EDR. There's also the question of who disciplines somebody who harasses people. In Title VII, it's obvious, so you're suing them. The financial redress is the discipline. The Judicial Conduct and Disability Act is the disciplinary process for federal judges. So you'd file a complaint. Judges who are harassing people are occasionally publicly reprimanded. They can theoretically be impeached and removed from office. So that is discipline for abusive judges. JC&D Act obviously does not apply to federal public defenders because their bosses are not judges. So public defenders have even fewer rights than law clerks, which is insane because law clerks basically don't even have Title VII rights. So how does this all apply to Karen Strickland? So Karen is a federal public defender. She has done all the right things throughout law school. She did several clerkships. She was a Supreme Court fellow. She starts working in this office in 2017. And the two heads of the office are the first assistant, a guy named PJ Davis, and then the federal defender, the head of the office. His name is Tony Martinez. And so pretty soon after Karen Strickland starts working there, she is singled out for harassment by the first assistant. He's described as lustful. He ends up stalking her. He insists on getting assigned to be her mentor, even though there's no mentorship program in the office. He insists on assigning all of his cases to her. She eventually starts leaving the office early just to get away from him. She complains about the mistreatment internally to the federal defender, the head of the office, and he basically brushes her off and he says, hey, this is like a marriage between employees. You got to work things out. So the mistreatment persists, and Strickland kind of complains about it again to the federal defender, again, the head of the office. He eventually assigns her to telework for like 6 months. But during that time, he does nothing to address the harassment such that she could return to the office. And during that time, she learns that all her coworkers are talking about her and saying she's making up this harassment claim to avoid going to work. So Strickland, after getting some advice from the Administrative Office of the U.S. Courts, which oversees the federal judiciary, she files an EDR complaint. Now, back in 2018, when she filed, it was an earlier version of the EDR plan. It has since been revised a little bit to branch off different processes for federal public defenders and for law clerks. So the 2018 plan was even worse. So she files this complaint, and then the judiciary basically does nothing about it. They sit on the complaint. They take like 6 months to investigate. They won't update her on the complaint. They won't do any. She wants to be reassigned to another federal defender office. They say no to that.
And all this time, she's just like teleworking?
Exactly. Yeah. So she is teleworking. And then the head of the office, she basically says, well, I want to be reassigned. I want to a different office. And he basically says no. And so her perception, after talking to some folks in the judiciary, is important. That the federal defender, the head of the office, is going to be the decision maker on her EDR complaint. Because while federal defender offices are part of the judiciary, judges are not federal defender offices' bosses. They are totally separate. They have to be, so that federal defender offices can protect the constitutional rights of defendants. So Strickland perceives that the federal defender who is involved in her complaint, who is a named respondent in her complaint, is going to be the final decision maker. And he has already said, I'm not going to reassign you. I'm not going to do anything to redress the harassment. So she eventually resigns from the office and concludes the EDR process, and she sues. And so that gets us to 2020.
So who that person in the office, theoretically, are the Fourth Circuit judges are above that position? It's just there's kind of like a wall when it comes to employment matters?
It is. Exactly. And several judiciary officials told Strickland that because there's this wall, the chief judge, who was Chief Judge Gregory at the time, will not meddle in the internal affairs of the federal defender office. And it would take the entire Fourth Circuit to remove a federal defender. It wouldn't even be the chief judge to remove them. So there's clearly going to be no discipline here. Wow. There's not going to be any redress for the harassment.
That's a new way of going en banc.
Yeah.
Apparently they don't do.
So she sues in 2020. She sues the Fourth Circuit. She sues the chief judge, the circuit executive, the federal defender, and the first assistant. And that is how this gets inter-circuit transferred, because she's obviously suing the circuit in which she works.
Right. So they have to have substitute judges for because everyone's conflicted. Yeah.
Basically. And at that point, she alleges a couple constitutional claims because, as we've discussed, federal public defenders, part of the federal judiciary, exempt from Title VII. So she raises both an equal protection claim, claiming that she was claiming intentional sex discrimination and retaliation, and then a due process claim related to the EDR plan. Both a facial challenge, it is unfair as written, and as applied, it was unfair as applied to her. So she also points out various due process issues with how it was applied to her. We talked about extensive delays. This was about a year of investigating her claim. She tried to get the federal defender recused because she was complaining about him. And he said no. And when she raised it with the chief judge, he said, well, who would represent the office? And she said, well, it doesn't matter. I'm complaining about him. Why is he deciding on the discipline for himself? So obviously very unfair. So this initially goes through inter-circuit transfer to Judge Young in Boston. And the district court initially dismisses her case and dismisses her case in its entirety, saying she did not have a property interest in the EDR plan. Now then she appeals, goes to the Fourth Circuit, 2022. Fourth Circuit partially reverses, says she can proceed on only her due process claim as applied to herself. So it was partially revived. Then we get to 2024. Then we get this 127-page district court ruling from Judge Young out of Boston, ruling for the defendants on all counts. And he says that the due process, that it was not, the EDR plan was not unfair as applied to her. On the equal protection claim, says that the judiciary officials, the federal defender, took concrete steps to redress the harassment she experienced. But what's interesting about that district court opinion is at the end, Judge Young expounds on various issues with the judiciary's internal process and says, look, while I'm not going to rule in favor of Strickland, we are not holding ourselves to the standard of an exemplary workplace that the judiciary is always talking about. We could do better here. So then Strickland appeals again, and it goes up to the Fourth Circuit. And then it's a 3-judge panel for judges from the 10th, 8th, and maybe the Second Circuit. I can't remember where the third judge is from. And this is where the opinion gets really interesting. In this 50-page opinion, I am not an appellate lawyer, and there's a lot of legalese. But at the end of the day...
I think our listeners are okay with not too much legalese. So
Yeah.
I was just going to say, so it's, Judge Benson from the 8th Circuit,
Thank
Judge
you.
Gilman from the 6th, and Judge Graber from the 9th.
So I got one of the 3, right?
Close enough.
Yeah. So on appeal, so the judiciary spends close to 50 pages expounding and kind of cherry picking the various facts that Strickland alleges. But at the end of the day, it's obfuscating a concrete issue, which is judiciary employees do not have the same rights and protections as other employees. So what they really harp on with this due process claim is first the fact that Strickland did not exhaust her EDR claim. After a year of waiting around, after Chief Judge Gregory had specifically said to Strickland that we will not consider any remedies until you conclude this complaint, she withdrew from the process. They also spent a lot of time talking about Strickland's misguided, as they perceive it, belief that the federal defender was the final decision maker. Now, they insist that that was unreasonable and that it was perfectly clear that Chief Judge Gregory, as the Chief Judge of the circuit, was the final decision maker on this claim. But as we have talked about, Strickland was repeatedly told that judges do not meddle in the internal affairs of these federal defender offices. So that's where we are right now. And as you mentioned, Strickland has sought an en banc hearing on her claim, so we are not done yet. But it is really important to understand that, the federal judiciary, judges are the ones who interpret our anti-discrimination laws, and yet they are not subject to these same anti-discrimination laws they interpret. These employees, including public defenders, they are ensuring the functioning of our courts, and they are lacking these basic workplace protections. So it's kind of like a confluence of errors throughout Strickland's EDR process that I would argue actually make it a due process violation. But at the end of the day, judges, when you file something in a federal court, if you use the wrong font, if you don't double space it, if you submit something double-sided, you are done. That small procedural error, you are out of there. So I find it really ironic that they do not hold themselves to the same standard for their workplace matters, that we could delineate 10 procedural errors that they have deemed not sufficient. So that's where we are right now. This is a really important case. Strickland is the only judiciary employee to ever assert her rights in federal court like this. And it's very relevant to lapse work because, of course, everything we do centers around the fundamental fact that judicial branch employees lack these basic workplace protections, and they are subject to these unsafe workplaces that they cannot redress in federal court.
So is that right? This is the only case where an employee who's gone through this internal process has then taken it to federal court?
That's correct. Yes.
Wow.
Yes.
Wow.
Yeah.
Well, Katrin, you are a former Article 3 employee who I know had a better time than this woman. Your thoughts about maybe this issue?
I mean, I think it's fascinating. I do not understand how this system works. Happily, I did not have to go through it. I had two great judges that I clerked for, and I'm thankful every day that they were as wonderful as they were. But I don't know if I would have the gumption to go through this process in the way that Strickland is going, and the fact that she's actually carrying forth and actually doing a federal lawsuit. That seems like an exceptionally complicated system that I don't know if I would be able to navigate. Like, I can navigate it at IJ for my clients. I don't know if I could stand up for myself that well. But it is fascinating to me how this entire system is organized, because I had no idea that federal public defenders fell within the system. And I have to plead ignorance. This is something I need to learn more about, because I do not know. And as someone who worked in the federal judiciary, I probably should have known a little bit about this.
Just a procedural question. So one thing that I thought this case was going to deal with, I thought, well, this will be how they wrap it up, is judicial immunity, because judges have immunity for all kinds of stuff, and we have talked about on Short Circuit in the past in all the ways that comes up. It's an absolute form of immunity, but it doesn't come up here. Do they think that it just not is how they approached it, or was there some reason that because it was a public defender it didn't come up? How does that work?
I think it just didn't come up. I think they felt that the ruling was sufficient dealing with the due process claim. The argument we hear from the federal judiciary is that they are, an independent branch of government, which I think is kind of crazy. Like, what are you independent from? The laws. I mean, I don't know that they think of themselves as having judicial immunity. I think they think of themselves as being independent.
Well, and I think, now I'm thinking more about it. This is judges. I guess they could have raised it, but I think maybe they would have lost, because judicial immunity comes up when they're working as judges, exactly. And here they're really working as supervisors.
Employers.
Yes. They don't need to be at a bench with a gavel in order to do that.
And I wanted to mention, because Katrin was talking about how she might struggle to navigate this process in a federal lawsuit. When you were a judicial branch employee navigating these processes internally, EDR or the Judicial Conduct and Disability Act, you were basically serving as your own lawyer. You were like a 20-something law clerk or like a 30-something public defender, like asserting your rights by yourself, going up against the full weight of the federal judiciary and their lawyers. And I mean, in this case, the Department of Justice was defending the judiciary, also some weird conflict of interest issues there. But I often talk to law clerks who are having a lot of trouble trying to assert even this modicum of rights, this modicum of protections, because they're on their own. And where are you going to find a lawyer who wants to go up against the judiciary in a jurisdiction where they go up against, where they appear before judges? So it is a terrible process. It's very unfair. I think the judiciary really, falls short in the systems they have set up here.
So one other question. So I'm not a huge fan of public employee unions, as listeners probably would guess. But I am a former union attorney, union side attorney a long time ago. And one thing I did see that it can be a good value of unions is when an employee gets in trouble with their employer and, they have a legitimate beef and the union can help them along. And I know that far goes to the other side to the wrong side of things all the time for bad employees. But I wondered if, someone does have a legitimate gripe, like it sounds like this woman has a good argument she did. Is there anything in the Article 3 universe that's kind of like federal employee unions that they have, in big executive agencies, or is that kind of missing too?
Great question. Law clerks, the judicial branch, also exempt from union organizing laws, so they cannot form unions, which is something I've been thinking about a lot. I think the judiciary would argue, at least for law clerks, well, these are temporary employees. They're only here for a year or two, so that should exempt them. But again, to harp on this, if you are a federal public defender, that is your whole career, 5, 10, 20 years. You are subjecting yourself to a workplace exempt from workplace protections. So they're exempt from union organizing laws. They shouldn't be. Employees asserting their rights as a group might help. When I talk to judicial employees, whether public defenders or law clerks, they always think, I'm alone, I'm the only one. If there were others coming forward, I might. So It's by design that the judiciary does it this way.
Right. Well, it's a really important issue. I think, whatever you think the finer details should be of workplace employment law, you can realize that there's an issue here. There's a problem. It came out a few years ago. I think it was around the time you were starting your project, that there was some testimony in Congress of people who had been mistreated by their judges. And because of federal life tenure, it is hard for that to come out sometimes. And so it is an issue that has been more in the limelight in recent years, but definitely deserves more attention.
Yeah. And Strickland was one of those congressional, she testified before Congress at that hearing where I provided testimony as well. And that was the first time she used her real name. She had initially sued under a pseudonym.
Yeah. Well, we will see where the case goes. It is currently pending en banc. But another case from the 11th Circuit is also about a federal law about your rights, but it is a little different. It has to do when the federal government hurts you and how you can get recompense for that. And it's really the only thing left when a federal official violates it's not even constitutional rights. It's just like hurts you in some way. Like, how can you be made whole for that? And that brings us to the FTCA and what happened to someone who went through something that we all enjoy, and that is transportation screening at the airport.
Oh, the joy of flying. Yes. So this case, like you said, is out of the 11th Circuit. It is Coletis versus United States. And it has to do with what happened to poor Elizabeth Coletis. At the time that her case arose, she was 4 months pregnant, and as she was going through security, she requested to undergo a pat-down instead of walking through the body scanner because she was concerned about the effects that radiation would have on her pregnancy. So TSA agrees to do a pat-down, and during the pat-down, the transportation security officer, and I'm going to quote from the opinion because I don't want to change any of the language, quote, engaged in a prolonged probe of Coletis's vaginal region, homing in on an unidentified material in Coletis's underwear. She then explains that the material is actually toilet paper to stem some vaginal bleeding from her pregnancy, but the transportation security officer is skeptical and decides to move her to an isolated room and to get a supervisor. The supervisor comes in and tells her to lift her dress and show her underwear. Coletis, I think very understandably, is not comfortable with this and instead asks if she could just remove the toilet paper and show it. The TSOs are not okay with this and they say, no, you have to lift your dress. So she does. The supervisor then pulls down her underwear, exposing her. Now, they are in a separate isolated room, so it's not like this in the middle of security, but nonetheless, very uncomfortable experience. And then they remove the bloody toilet paper. Once they have seen that she was telling the truth, indeed the unidentified material was just this toilet paper and there's nothing else suspicious, they allow her to leave and proceed through security. Now, I will not speak for Coletis, but if I were in her situation, I would be horrified and I would probably be traumatized by the experience. And it seems like she was, because she developed various psychological and physical symptoms as a result of this strip search and decided that she wanted accountability. So she decided to sue the federal government, as Anthony said, using the Federal Tort Claims Act. She specifically sued for battery, false imprisonment, intentional infliction of emotional distress, and for negligence. Now, if you're a regular listener, you're probably somewhat familiar with the concept of sovereign immunity. And here it is. So as a reminder, sovereign immunity is the general idea that you cannot sue the government unless it allows you to sue, which to me still sounds wild.
I mean, that's why we had a revolution, right? So we could have permission to sue the government.
To ask for permission, yeah, excellent. And so usually the way you get permission to sue the government is through different statutes. The FTCA is the statute that applies to cases against the federal government. It creates specific exceptions to that general idea of sovereign immunity and therefore allows people to sue the federal government in certain circumstances. Now, the FTCA is very complicated. Much more complicated than we have time to get into today. But the most basic things you need to know is that the FTCA generally, again, it's complicated, but generally allows lawsuits for certain negligent acts. But it usually does not allow lawsuits for intentional misconduct.
So the postman driving into your mailbox negligently, that you can get a claim for. But
Yep.
if he just hates you and took a baseball bat to your mailbox, that's an intentional tort. No, you can't get that.
That is usually how it works, yes.
That's actually the law.
Usually how it works, yep.
Yep.
It's the wild, wild world out there. Intentional misconduct, we would call intentional torts, generally not covered. For Coladas, this is a problem because all the things not all the things, the vast majority of the things she's complaining about are intentional torts. Battery, false imprisonment, and intentional infliction of emotional distress, all intentional torts. So the question is, can she even sue if these things that were done to her are intentional torts? Luckily, in this case, the answer is yes, she can sue, but that turns on a question of statutory interpretation. So, like I said, at its basis, the FTCA is a waiver of sovereign immunity, but it has a bunch of exceptions to that waiver, including relevant here, intentional torts. The good thing, or no, the complicated thing that sometimes is useful, is that those exceptions sometimes also have exceptions. So the FTCA is a waiver that sometimes has unwaiver exceptions that then have their own exceptions which re-waive sovereign immunity. In this case, one of those exceptions to the exception is something that we have litigated at IJ, including at the Supreme Court, which is the law enforcement proviso. And so the question is...
Do you say proviso, by the way? I say proviso.
Proviso might make more sense. Frankly, I'm not good at pronouncing words I don't often hear heard.
No, that's cool. You can go with proviso.
Actually, I like proviso. It sounds fancier. Is this going to be the new en banc en banc debate?
Oh, yeah. Well, we'll do that another time.
Anyway, the point is that it allows for suit for intentional torts when those lawsuits arise from, and this is straight from the statute, acts or omissions of investigative or law enforcement officers of the United States. Those officers are then further defined as officers that are, quote, empowered by law to execute searches, to seize evidence, or to make arrests for violation of federal law. And so now the question becomes whether TSOs are those types of investigative or law enforcement officers. If they are, then they fall under the proviso, and her lawsuit can move forward. If they are not, then the FTCA's sovereign immunity waiver does not apply to any of the intentional torts she's complaining about, so her lawsuit can't move forward. And so this seemingly narrow statutory interpretation ends up being a very big deal because this is essentially the only path that she has to hold these TSOs accountable. That's in part because the Supreme Court keeps narrowing Bivens, but that's a whole other complaint that we could go into another time. Here, luckily, the court did recognize that TSOs are investigative or law enforcement officers within the meaning of the FTCA, and that her claims can move forward. In coming to this conclusion, they engaged in a very thorough statutory interpretation discussion that covered a lot of different things that you would consider in statutory interpretation, everything from plain meaning of words to using dictionary definitions to weighing linguistic and substantive canons. If you are a law student who's about to take your legislation final for the semester, read this just to see how all of the different things you've been studying work out in real life. It is, and so there's just the details of the discussion. There's a lot of different things that are discussed, so I can't get into all of it, but there's a lot of interesting things there about how you interpret a statute that is this complicated. One of the things I found particularly interesting about that part of the discussion as a constitutional litigator that's been thinking about the Fourth Amendment a lot recently is about how they determined what constitutes a search and whether what TSA officers do is a search. Here they said that obviously it's a search, it's very invasive, the screening process that you go through. The government actually tried to argue that this wasn't a search because TSOs aren't law enforcement, they can't arrest you. not the Supreme Court, the 11th Circuit law-dogged that. They said, no, essentially what the screening process is a search. You can't just get around it by saying that only if they can arrest you, then it would count as a search. And so that's very interesting discussion there. Another part of the discussion I thought was interesting was how the court weighed non-binding court opinions in its analysis, because the lower court in this case, the trial court, had said, no, they aren't officers, and they did that based on a prior 11th Circuit case that was unpublished and therefore was non-precedential, that had said, hey, TSOs are government employees, they're not officers, therefore they can't fall within this provision. But in the meantime, there had been a series of cases from other circuits saying, no, they're clearly officers for the purpose of the law enforcement provision. That word.
Yeah.
And so, and so there's an interesting discussion there of how you weigh different persuasive authority. Here they said, no, we're going to go with the other circuits because their analysis was textually based, that actually looked at all of these issues. The unpublished 11th Circuit opinion hadn't really delved into any textual analysis of the FTCA. And so just as someone who has been at a district court and knows how hard it can be to make a decision when there's no on-point case law, I found that interesting. But even with all those other things covered, overall, I think this case is important for a much bigger reason, which is it holds that the FTCA means what it says. And that's a really big deal because so often the FTCA is interpreted very narrowly in ways that make it really difficult to bring cases against the federal government, even when the FTCA is the only option available. So for me, rejecting the idea that the FTCA should be narrowly construed as a waiver of sovereign immunity is a meaningful win for anyone that really wants to ensure accountability for federal government officials. As we've already said in this podcast, at IJIG, we use the FTCA a lot. It was a big part of our win earlier this year. And so seeing the 11th Circuit actually go through this analysis and say, yes, the FTCA's waiver means something and it can actually be used, I think is incredibly important.
Aliza, I'm just curious, the FTCA, I'm pretty sure it's pretty clear it doesn't apply to Article 3 employees, but I wonder if it's come up at all in what you've looked at.
It hasn't, but I feel like somebody asked me that recently.
Yeah. No, I mean, when it was adopted, it was about the mailman hitting your mailbox, or as we say in a Bound by Oath episode that I will put a link to in the show notes. The ultimate real catalyst why it finally was adopted was a plane hitting an army plane accidentally hitting the Empire State Building in 1946. It really was an accident, but there was there was no mechanism to sue the United States for that negligence. And so it was that kind of thing that is the reason for it. But then it only gave so much. And then there was all these clawbacks, and then you couldn't sue law enforcement officers, as we said, for intentional torts, like when they do really bad things in their law enforcement powers. And so it comes to this. Now, one thing in the background, right, and this wasn't an issue in the case, but in the background is you can't sue these individual officers because that's a long story, but basically because of this thing called the Westfall Act, from which merged kind of the old practice where you would maybe sue the United States in federal court, but you could sue these officers in state court for just state negligence law or intentional torts under state law. But then it was all just merged into the FTCA. Now, whether Congress constitutionally could do that or not, maybe is an interesting question. But that wasn't an issue in this case. And so because there's also the Bivens doctrine, but that's about constitutional claims. If you're not talking, and that has been largely abrogated. So this is really all that's left. I just got super confused talking about it myself. So that kind of shows the practice, the state we're in. I will say for listeners, if you're interested in how the FTCA applies to the military, not when the military, like a soldier sues the military itself, then it completely does not apply. But to ordinary people, and whether like TSOs, are they different than soldiers, which seems to be an issue these days sometimes, the military being involved in certain activities. There's a essay I wrote recently for The Unpopulous that tries to unpack some of that. Although I got super confused writing it, I will admit. So we'll put a link in the show notes to that too.
See, but that's an excellent point. Even an expert gets super confused.
Well, I don't know if I'm expert, but I became a little more expert trying to wade through those issues. But I think that the bottom line from this case, as you said, Katrin, is taking the text seriously. The FTCA does, maybe it's not maybe, it is not perfect, but if you take the text seriously, it does provide some remedies to people. It does provide something at the end of the path in certain situations, and it just makes sense that they're law enforcement officers. I mean, if I went through a checkpoint and didn't pay attention to what they said, like what happened to this woman, and just walked through, I mean, of course they can arrest me. They can do all kinds of things. They're law enforcement officers.
Yeah, during the oral argument, there was this incredible back and forth where the government attorney is saying, well, no, they're not law enforcement officers. And the judges are like, well, if they were trying to carry a gun through security, would that be fine? It's like, well, no, but that's because then the cops would go get the gun, not the TSA officers. And it was utterly wild to hear that exchange and the fact that they were actually making this argument. But
yeah, I don't think that's actually true, but they try what they can. But we've tried what we can to educate our listeners today. So thank you both for coming on. Aliza, if you could say one more time where our listeners could find your information, what you have to offer.
Yep, legalaccountabilityproject.org is our website, and you can go there for information. We're recording this on Giving Tuesday, so if you feel like donating. And then importantly, our clerkships database is survey.legalaccountabilityproject.org. If you clerked and you want to review the judge you clerked for, awesome or terrible as they may be, where we always want more information. And if you're a student applying for clerkships, go there, pay $50, register, get access to information. Knowledge is power. You don't want an experience like Miss Strickland's. So.
Well, thank you so much for that. And we'll put, as I said, we'll put a link in the show notes also. And thank you, Katrin. And thank you for listening. And please be sure to follow Short Circuit on YouTube, Apple Podcasts, Spotify, and all other podcast platforms. And remember to get engaged.